All right, we are broadcasting live. Welcome to
Hey,
Morgan and
one
Morgan.
second, Phil.
Oh,
We
okay.
don't. They're filtering in right now.
Okay. Welcome to Morgan and Morgan Insurance Recovery Group, production of Fight for Your Business Interruption Insurance Claim Payout. Brought to you, your host and guide today will be double board certified trial lawyer Mark Nation. I'm Phil Sanoff, trial lawyer with Morgan & Morgan's Insurance Recovery Group. With Morgan & Morgan's Insurance Recovery Group, I have got 55 of the most awesome attorney colleagues you would ever want to know. We are in 25 offices, 13 states. If you have any problem with any insurance claim, you need to come see us. You can reach us through our website, forthepeople.com. Hit pound LAW from any cell phone, or just call me on my personal cell. We will figure out how we can help you. 713-825-3444. Morgan & Morgan's Insurance Recovery Group. Come see us. We are here today to focus on interruption insurance claim payout, leading our discussion and giving a group, Mark Nation. When Mark takes over, I will be monitoring the Zoom chat. If you want to type out questions and comments, we will then ask you to please join live and interact with Mark to have your question and answer interaction there live. It makes for a much more productive and efficient interaction with the webinar question and answer format. The electronic raise your hand in your attendee list. You can go to your name, click it, and it will electronically raise your hand. Again, we will unmute you so that you can interact live with Mark discussing either your business interruption insurance claim, any other type question you may have. With that, I'm going to give it to Mark to take away, and thank you for joining us at Fight for Your Business Interruption Insurance Claim Payout. Mark, please take it away.
All right. Thank you, Phil. Thanks very much. Glad to be here and happy to be here to answer questions. Let me just ask Ned something, because on my end, Phil's was cutting in and out a little bit. Ned, are we?
I was getting that, but you're coming through loud and clear.
Excellent. Well, that's what happens in our modern day here. So I do thank everybody for coming today. I was thinking today that one of the benefits of doing this every week at 5 o'clock is throughout the day, I'm getting calls and I get the same questions many times throughout the week. And what I've been doing is, because I can't talk to everybody and do my regular work, what I've been doing is asking people just show up at the webinar, 5 o'clock on Thursdays, Eastern time, and then ask your question, because the questions that most people are asking are common. I might, if I was to take every phone call, I'd be answering the same question 10 or 12 times a day. And so the most important part of this webinar is you and your questions, because if we don't have your questions, then we really don't have a webinar to put on. So I really appreciate Phil's introduction. We work together, and again, we've got over 50 lawyers handling these types of cases on behalf of policyholders. I myself have been representing policyholders for the past 30 years. I've had hundreds of business interruption claims, thousands of claims on behalf of policyholders. It's what I do day in and day out. And I really have a passion for helping policyholders. And it's not just these claims, it's any type of claim, whether it's a homeowner's claim, life insurance claim, disability, health insurance, accidental death, homeowners, business owners, it doesn't matter. If your own insurance company says no is low or slow, that's a good case for me to take a look at. And I'm going to get into some nuts and bolts in a minute about business interruption that'll maybe spark some questions, and then we'll get right into your questions. But before I do that, if I could only get one thing across, let's say I only had 1 minute to talk to you here today, what would I say? And it would be this. So this is the most important part. Just because an insurance company or an insurance agent says your claim is not covered, there's no coverage, there's an exclusion, it's denied. If they say anything like that, here's my message to you. Let us look at that for free. And I'll look at your denial and tell you whether or not the insurance company is doing the right thing. And if they are, you deserve that peace of mind from an advocate for you as opposed to an advocate for the insurance company. And if they're not doing the right thing, I'll tell you that too. And so don't be intimidated by a denial. Don't be intimidated by no. No is not the end of the inquiry. It's just the beginning. And in fact, every case I've ever won, they all have one thing in common. They all started with no. And so don't let no be the end of your claim. Let it be the beginning. In fact, it's the one thing I need to win. I can't win your claim until the insurance company says no. And so even if you think there's nothing that could be done, let us look at that for that denial for free. If they're right, we'll tell you. If they're wrong, we'll tell you that too. All right, let me get into a little bit of business interruption. However, if you have any claim, a question about any claim, you can bring it up on this webinar, and I'm happy to talk to you. In fact, I really look forward to this. It's one of the highlights of my week is to be able to talk to you directly about claims that you may have. And so it doesn't matter if it's health insurance, life insurance, disability, homeowners, business owners. I don't care what it is. If you've got a question and it's a legal issue, you ask me. And but I'm going to direct right now us to the screen. I'm going to talk a little bit about business interruption, but you can ask me anything you want. So let me share my screen. And by the way, this is the same place and the same screen and the same setup that I use for court hearings. I had 2 of them yesterday right here. And I've had, probably 20 hearings now with judges, just like I'm talking to you here today. And then I am able to share the screen. One of the things I found in doing these hearings, and I've done hearings like this by video actually for years, this isn't new for me, is the screen share capability that we have is far, far better than what the defense bar has, far better. And it's because the setup we have is specially designed for presentations like what we're doing now and to courts, as opposed to simply reading insurance policies over a Zoom. We go through them in writing. So let me show you how that's done, and we'll get this started. All right, here's the first thing I want to say is insurance companies have done a very good job of mismessaging what's going on with these insurance business interruption claims. They have done a very good job of getting their message out that these claims are not covered, but they're wrong. Some are, and some may not be. And I like to start, I would like to start us with just drawing this spectrum. On this side, and I'm going to use, let me use this. I'm going to use black. And I'm going to put BI for business interruption, covered. So your claim is covered on this end. And then on this end, not covered. And so we have a broad spectrum of different types of policies. And it goes all the way from covered to not covered. The insurance companies would have you believe that none of them are covered. But in reality, I would like to explain it this way. This end is covered. These claims are covered. And then we're going to go over here and say these claims are not covered. Now, you'll see in the middle here that there is an interaction or an intersection right here. And there are some cases that we just don't know the answer to yet. Depending on the language of the policy, they're going to fall into this category. But the message I'd like to get out and make sure everyone hears is there's going to be some that are right over here that are covered. And there's going to be some over here that are not. And there are going to be some right here where the judges, the trial courts, are going to have to give us some direction, and ultimately the appellate courts are going to have to give us some direction on whether or not these are covered. And so the real message that needs to get out to business owners is some of them are covered, some aren't, and there's going to be some we just don't know about yet. And so you need to file your claim. And if you have not filed a claim, there is no harm in doing so. File your claim for business interruption, and let's see what the insurance company does. But here's what I do not want people doing. Don't call your agent and ask whether or not it's covered. Most of the agents are just telling their clients, it's not covered. It's not covered. Don't waste your time. Some don't. Some say, no, it could be. Why don't you file it? There's no harm in that. And then they're filed. But most of them, from what I'm hearing from my clients, the agent has told them no point in covering or filing it. They're not covered. And then people don't file a claim. Now, what does that result in? About 10 minutes before this webinar, I got, in a different case, not one of these, but it's a policyholder case, a motion for summary judgment from the insurance company because the insured person failed to give what's called prompt notice under the policy. So each of these policies has a provision in it that says you must give prompt notice of your claim. Failure to do so could result in us avoiding or voiding the claim. Now, there are ways around that, but I'd rather not fight that battle if we don't have to. And so you need to give prompt notice. Now, don't worry if you haven't given it yet. We're still good, but it needs to be done, or you're giving the insurance company, you're handing them another defense to the claim, and I'd rather not hand them ammunition to use against you. And so file the claims. And people ask, well, will my rates go up? Whether you file this claim or not, your rates are going to go up. They've gone up every year you've been in business. And now is a time when you need it the most. And so if it goes up a little bit, it's going to go up anyway. File the claim. And let's see if there's coverage, because some of them are going to be covered, some are not. And then there's this middle ground. In the claim itself, this is just a basic claim that we would do on behalf of people. And I recommend that let us do the claim on your behalf, because there are some landmines and traps that people fall into in making the claim. But it's a basic document. And you don't want to fall into the trap. I'll give you an example. I had a client who submitted the claim, says, I want my coverage for civil authority. And the insurance company wrote back and says, you don't have coverage for civil authority. Now, they didn't mention that he had coverage for time elements. It's called time elements coverage. It's the same thing as business interruption or business income, but they called it something else. But because his letter didn't mention it, they didn't address it. And so the only thing I'd like to make clear to people is if you submit it on your own, you don't need to, because we'll do it for you. Just say you've lost income, had extra expense, and suffered other losses as a result of the pandemic. And then don't fall into their trap. I'm hereby presenting a claim for all coverages available under my business policy or policies. Now, you could end it there, and that you've properly submitted the claim. But I'll go on and say for this loss of income and extra expense. I'm sorry, you could end it there, but I do go on and say it includes but is not limited to, and then I use the words that they use. Normal, continuing expenses plus gross profit, lost income, extra expense, and any similar benefit under the policy or policies. and then the claim is on file, you've then taken away from them their prompt notice defense. And so you want to do that. Let me see what the next screen, this is, and I'll go to the questions in a moment. These are typically the types of recoveries. These are generally what you get when you file and they pay out a claim for loss of business income or business interruption. Normal continuing operated expenses plus profit, and then extra expenses incurred because of the suspension of operation. Some businesses have to incur special expenses and shutting down and that type of thing. That's generally what you can recover. There are other types of losses you can recover too. And that was the first complaint we filed. It was on behalf of a dentist, and we filed many now on behalf of dentists and other professionals, brewing companies, beauty salons, restaurants, you name it. I've got hundreds of these cases now throughout the country. All right, and this is a typical policy that has the coverage here. They call it business income. Now I'm going to get into the nuts and bolts unless we have questions. Ned, do we have any questions at this point?
We do. We have a question from John. John, I'm going to unmute you here, and you can ask your question.
Hey, John, welcome aboard. How are you?
John, I think you still have to unmute yourself. I gave you the permission to unmute, but I think you have to. There it is.
I own a restaurant in downtown Orlando, and I had heard that the state of California was a little further along in litigation on filing these claims, and some attorneys were waiting to see how that played out before, to see, you know, how we should proceed.
Yep.
Has there been any movement in that at all, where we can see maybe a path to getting some kind of resolution?
So that's a great question. Let me, and you don't have to answer this question. Is it a restaurant downtown that maybe I've been to?
Have you been to Hamburger Mary's?
Nope.
No, right downtown in Church Street Station.
Okay, I love the name. Love it. So here's what happened. In California, there were a group of chefs that got together and immediately filed suit,
Okay.
which is fine. And I've got friends who are lawyers in California, and for my clients who call and have a California case, I have a specific lawyer I refer them to who does this kind of work day in and day out, who I trust. That raises a good point. Let me get to your answer in a minute. I did not make this point earlier. A lot of lawyers are taking these cases, but they've not done these kinds of cases before. I was just on the phone, what's today, Thursday? So Tuesday, with a lawyer in another state who does car accidents, and he had filed one of these claims on behalf of his client, a business interruption claim. And I called him and I begged him to dismiss his claim, because his lawsuit, because it was not done properly, was not done in the right way. And there was about to be a very bad ruling in that case. And I am, and this is no exaggeration, I am more afraid of plaintiffs' lawyers who do it on this side, representing policyholders. I'm more afraid of lawyers who represent policyholders screwing this up than I am the defense lawyers who I'm going up against. You see, I know what the defense lawyers in these cases are doing, and I know what the defenses are, because I've been doing it for 30 years, day in and day out. And I know them, and they know me. But the plaintiffs' lawyers, especially ones that are coming on board and dabbling in this, I keep a list of them, and I'm constantly calling them. It's like whack-a-mole, trying to help, say, hey, don't make this argument, make this one. Don't say this, don't do that. And so I understand that a lot of lawyers are sitting back and seeing what happens. Now, technically what happens in California ain't gonna matter here in Florida too much. Although it could, I mean, if it's good case law, we'll try to use it here in Florida, but it's not precedential. It may be persuasive, but not precedential. However, let me answer your question very specifically. I ain't waiting for nobody. I want to be the one making law in this area, leading the charge, and not having somebody else trying to blaze a path that they've never been down before. And I am scared to death that lawyers out there who don't do this kind of work are going to be out there just blindly swinging, trying to get things done. They end up getting into the appellate courts before I do, and then I'm stuck with what they did. And I'm very particular about how we make the allegations in the complaint, the affidavits that we use in support of the tool that's going to be used to resolve this is called summary judgment. And preparing those summary judgment motions appropriately and getting the right evidence in front of the court through affidavits for summary judgment so that it is appropriately teed up so that we can control the direction of the law and help shape the law as it is developed in this area. That chart I did at the beginning, that area in the middle, that's sort of no man's land, we're unknown what the courts are going to do. I don't need a dabbler trying to get that done. I want it to be us. So to answer your question, there are a lot of lawyers sitting back waiting. You don't want that lawyer. I'm filing these cases because I want to be the first one into the appellate court because I know what I'm doing. That's kind of the answer to I think that answers your question, right?
Yeah. Yeah. I mean, I initially had been approached by a different law firm, which I did not go with. And I've already put through my paperwork through Morgan & Morgan and sent through my policy and the declination letter. I used to sell insurance years ago. So,
okay.
I'm all in with you guys. So I'm just hopeful that, business owners, restaurants especially, we need the money soon. And yeah, so I know this is going to be a process, but I'm not 100% confident that's going to happen as quickly as we need it to.
It's not. Let me show you on my screen exactly what one of my concerns is, because this is a question a lot of people have, and I appreciate your question. And I hope I wasn't too bold and upfront in giving you my answer, but
no, I appreciate it.
That's the answer. Is I do appeals. I not only do trials for policyholders, but I do a lot of appeals on behalf of other lawyers throughout the state when they have cases like this, an insurance case, going up into the appellate courts. And so at any given time, I've got not only trials that I'm doing, but appeals in each one of our district courts of appeal and the Supreme Court of Florida on the issues that we're talking about. And so I want to have my hands involved and help shape and direct the development of the law. And we cannot wait. If I would blow a gasket sitting back waiting to see what other people did. Let me give you a for instance here. Because this is the money shot right here in these cases. And this is what the insurance companies are ignoring, and they're doing it willfully. So again, this is bankers, but this is typical. This is a typical business income policy. They almost all say exactly the same thing. First of all, the first thing I want people to know is, and it's interesting that this happens, all right, our business income policy is in your property coverage. It's not in some other portion of the policy, it's in your property coverage. Meaning when you filled out your application, you had to put your industry code in. You're a restaurant. If you're a manufacturing facility, you would put that in. They develop the premiums based on what you do for a living. But it's in the property policy portion of the policy because there's a recognition. If you can no longer use your property for its intended purpose, you will have a loss of income. So that's the concept. And obviously, if it burns down, that's a great example. Burns down, you've got fire damage, you're going to lose income as a result of that. And so that's why it's stuck in the property portion of the policy. But you said you've already gotten your denial, right?
Yes.
Okay. Now, let me show you what the policy says, and then I'm going to show you what the insurance company does. It says here, the suspension, and that means the suspension of your operations, must be caused by direct physical loss of or damage to property at the described premises. All right. So that's the coverage right there. That sentence. They ignore this or. So there are two triggers for coverage. Not one, there's two. The suspension must be caused by, one, direct physical loss of, or two, damage to property. So it's direct physical loss of, and that's really an important word, of, or damage to property. Two different triggers. Let me give an example. Somebody steals your car, you've had a direct physical loss of your car. There's no damage to it. There could be, but in our example, they just stole your car. It's not damaged, but you have a direct physical loss of your car. You can no longer use it for its intended purpose. That's what direct physical loss means. Damage is something totally different. However, the insurance companies, in their denial letters, pretend like they don't know the difference, even though they wrote this policy. They deny it and say, you have no direct physical damage. They conflate the two. I don't know if yours did. I may have already looked at it, but I suspect they said something along those lines.
Right.
But that's not the trigger.
Mm-hmm.
The trigger is direct physical loss of or damage to property. Oh, I'm not going typically under the damage to property here. You're a restaurant, you got shut down because of all these governmental orders. And that is, you can no longer use your building for its intended purpose. That's direct physical loss of, just the same as if somebody had stolen your car. And that's the trigger for coverage. Now, there's some good case law for us on that direct physical loss stuff. In some states. In other states, not so good. In Florida, we're going to see. I think there's really good law on that. It's my position. The law is very supportive of us on that. We'll see. The defense bar says no, no, no. Their defense is you got to have damage. Before you get any coverage, you got to have damage. That's what they're saying. But that isn't what their insurance policy says. It distinguishes between those two. All right. Any other questions or thoughts?
John, does that answer your questions?
Yeah, it does. Thank you. I appreciate it.
All right, and I appreciate the question, John. All right, anything else, Nan?
Yeah, we have a question from Josh. Josh, I'm unmuting you here, or permitting you to unmute yourself.
Thank you.
What's happening,
Mark,
Josh?
not much, just trying to get by like everybody else. My question is, what about how does this work for businesses that are like mostly shut down but are allowed to do something? So like a restaurant that can't have people in but can still do carry out.
All right, let me show you here. In that, let me share the screen. It's going to depend a little bit on the policy. And some policies are going to require total suspension. All right, total suspension. Now, there's some wiggle room in the language they use for that. Some policies will require some suspension. And then there's a third thing that happens. Let's say you're out of business now, we're going to go ramp back up. And I call it ramping back up. So now, let's say you've been totally shut down for 2 months. Ramping backing up. You've been shut down for 2 months, nothing. And it's going to take a while for you to get back in the full swing of it. Some policies have coverage that's going to give you where you've got diminished profits. They're going to pay you during a phase where you would be getting back up into business full time. And that usually has a time limit on it. And so it's just going to depend on the policy. Number one, total suspension. Again, you're going to get some wiggle room depending on the language. Most of the policy, there just has to be some suspension of operations. And then the third, and very importantly, coverage for while you're ramping back up into full swing of business. There are nuances to each one of those, but those are generally what we got going on. Does that answer your question?
Yes, thank you so much.
All right, no problem. What else we got, Ned?
Thanks, Josh. We have a question from Seth. Seth, you should be able to unmute yourself now.
Seth, what do you got?
Sorry about that. It wouldn't unmute. If my insurance company's asked me to provide them accounting documents and a bunch of information trying to prove that I've lost, is that something you can help with or something I need to contact an accountant to handle?
That is something we can help with, and I think it's important at that stage that they're asking for that you have representation from a lawyer who knows what he's doing. And it's important that the lawyer be experienced in this area of the law. The problem is if they're asking for that stuff, but they haven't made a determination on coverage, they're sort of putting the cart before the horse. And you would want to get a determination on coverage first before you incur all these expenses. It is expensive to work these claims up. You want to have a determination on coverage before that happens. Also, what we use is forensic accountants who really have done, I have one that's done over 30,000 of these claims in BP litigation. And we know what to do. We know the documents you need because the policy doesn't cover exactly what you think it covers. And you need to present the claim in a manner that the insurance company then will more likely receive it in a better light. If you just give them a pile of documents, you're giving them a pile of excuses not to pay. But if you present it to them in a way that is on what I call it on a silver platter, since we know exactly what they need under their policy, they have a much more difficult time avoiding it. But if they do avoid it, then I'll make them look ridiculous in trial because I'll show what the policy requested. I'll show how we complied with every one of those conditions and gave them exactly what they asked for. And then they pretended like they didn't know what we were giving them or that they didn't have enough information. And if you can't trust the messenger, you certainly can't trust the message. And so when they start dinking around with those little things after they've been given the silver platter, they look ridiculous. And so that's something not only we can help you with, that I would prefer that we do for you. If you give them a big pile of papers and you're just giving them the ability to go, well, we didn't know and we couldn't tell, and this, this was confusing to us. If we give it to them on the silver platter, they're still going to say that probably, but they look dumb when they do it. All right, anything else?
Seth, does that answer your question?
Yes, thank you.
All right, appreciate it. Anybody else?
We don't have anything in the queue right now, Mark.
Let me talk about one thing then. But a lot of people have heard that there is the virus exclusion. And so there's a concern, hey, my policy says virus, it has a quote virus exclusion, so I probably don't need to file a claim, right? The answer is file your claim anyway. File it anyway. And I'm going to share my screen again because I want to show you something. Let's see. So I talked about, let's see where I was. Let me back up on this board. It's the next one after this. I talked about this coverage being, there's two triggers for coverage. Direct physical loss of or damage to property. There are two triggers for coverage. And I remember at the beginning of this, I drew this picture. And I said, look, there are going to be some policies that cover it, some that don't, and there's going to be a no man's land where the courts are going to have to give us some direction on some different items. Now, the same thing applies to these exclusions. There are some policies that have no exclusion whatsoever. I was looking at one yesterday, and I looked through and I searched for the word virus, and virus showed up about 15 times. But it was talking about computer viruses. And it had no virus exclusion that would cover this situation. that's kind of a silly example to say, look, just because it has the word virus in it doesn't mean it's excluded. And a bunch of these policies have no exclusion at all that's going to be triggered, none at all. And some of these policies are going to have an exclusion that looks like it applies, but it doesn't. So let me show you what I'm talking about. So I showed you here that there are two triggers for coverage: direct physical loss of or damage to. All right, now let's move forward. Let's look at here's a basic exclusion. And the insurance companies are using this routinely on these COVID-19 claims and saying it's excluded because this is a microorganism exclusion, and it's, by the way, an absolute one, so there's no confusion. Policy does not insure for any loss or damage arising out of or relating to any mold, mildew, fungus, spores, microorganism, blah, 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 whose presence poses an actual or potential threat of human health. That seems ominous, but let me tell you, it doesn't apply. A virus is not a microorganism. It's not an organism at all. A virus is not alive. If you look at it, and the scientists will tell you, it's not a living thing. An organism is a living thing. And so I've got a microbiologist, PhD professor, who will come in and testify in every one of these cases that a virus, and I've had him do a literature review, a virus is not a microorganism. The insurance company might want it to be, but do you see they don't have the word virus in here? Now, if they had the word virus, I would say, well, it's not a microorganism, but you've included it, so I'd have to have a different argument, and I do. But they don't even include it here. And so this doesn't apply, but people are getting these denials with this exclusion, and it's covered. Let me give you another example. All right, here's a typical one, and this is an exclusion due to virus. So I know people are seeing this, and they go, there's nothing I can do. I know Nation told me, let him look at it, but he obviously wasn't thinking about this because there's nothing I can do about this. Wrong. Let me give you an example. All right, A, the exclusion set forth in paragraph B applies to. All right, so let's stop there. Every word matters. So B is the exclusion. The actual exclusion is in B. Now, the insurance company in a denial letter would cite you B. They'll cite, we will not pay for loss or damage caused by or resulting from any virus. And they're going to cite that. They'll ignore A and cite that. But A is the scope of the exclusion. A defines the scope, the cases to which it applies. B sets forth the exclusion. So let's see the scope of the exclusion. All right, it applies to all coverage under Section 1, okay? In all forms and endorsements that compromise this business policy, except as provided, blah, blah, blah. All right, this includes, but is not limited to, forms and endorsements that cover property damage. Now, you'll remember, as I've said it 20 times, there are two triggers for coverage. There's two. One trigger is direct, D-I-R-E-C-T, physical loss of, or, and the second one is damage to property. All right. 2 triggers for coverage. Let's, with that in mind, keeping that in mind, let's relook at this. The scope of this is all forms and endorsements that cover property damage. That cover property damage. This scope of this endorsement does not apply to the types of loss we're talking about in this circumstance, which are the direct physical loss cases. If they intended for the scope of this virus exclusion to apply in our circumstance, then very easily, here's all they had to do. They just had to do this. Endorsements and settlements that are endorsements that cover the same way they did it in the trigger for coverage. They would do it in the scope of the exclusion. They cover, they just quote it the way they did earlier. Direct physical loss of or damage to, here, I'm sorry, I meant to put it there, or damage to property. The same way they wrote the trigger. Yet in this case, they limited their exclusion, the scope of it, to those types of claims that are a result from property damage, not the direct physical loss type. So that is my advice. Don't review these on your own without the help of an experienced lawyer who does this day in and day out, because every word matters. There are other things
Mark,
in this. Yes.
We have a question from one of our attendees who's on the phone. He emailed me, so I'm going to read it to you if that's okay.
Perfect.
Do we need to have filed a claim? I talked with the agent who is an independent agent. Of course, he said the claim would be denied. In my policy, it states virus and bacteria. We are a cleaning company.
File the claim. Let us file the claim for you. We'll file it, and then we're going to see what the we'll see what the policy says, and we'll file it. I think that's the best course of action.
He sent me his number, so I'm gonna unmute him. Robert, can you hear me? Are you there?
Yes, I can.
Hey, Robert, how are you?
Hey, Mark, how are you? Thank you for taking my call.
Thank you. Tell me, so did I answer your question? You need to file the claim, or let us do it for you. I know the agent's saying it's not covered, but I'd get it filed. You've heard what I've been talking about. I don't know if you could see it, but depending on the policy, these are covered. Some are not covered. Some are in no man's land. We're going to need some direction from our courts. And so my advice is to file the claim.
Yeah, I want to file a claim with you guys because even in my policy, it says there's a $50,000 limit on it.
Is it Hartford? Is Hartford your carrier?
Yes.
Okay. Does that sort of indicate to you, maybe I know what I'm doing here?
Well, when we met several years ago, I had that same impression.
Okay. So I know Hartford's policy as well as I know Bankers and Lloyd's, and they've got a $50,000 limit, but that $50,000 limit applies to the damage types of claims. And so that limit applies when you've got a cleanup. So it goes on to say, the most we'll pay for cleanup is $50,000. It's not a direct physical loss limitation. And I filed several claims so far for Hartford policies because that just doesn't apply. But don't file the claim through your agent. File it with your insurance company. You can certainly send them a copy of it, but don't file it through the agent because the agent will call you and go, hey, it's not covered. And then people weasel out or wiggle out of it and then say, well, okay. They get cold feet.
Well, I'll tell you what, if you want to email me the address and that where I can set up a time to get the policy and sign the documents or whatever, we can get it going then. I'm in Orlando.
Yeah, you'll get an email after this that'll have a link where you can go right online at forthepeople.com and you can enter in all the information we need. And then
sounds good.
We'll get started.
I appreciate it. And like the other gentleman, I've had several other attorneys send me stuff, and of course they were based out of state. And I said I'd rather. First of all, I wasn't even sure, trying to fight to get through what's going on. I was worried about that. And then I said I'd rather deal with somebody local. And I didn't even know Morgan was in this line of work. So that's very helpful.
Excellent. Well, thank you, Robert. Appreciate it.
I appreciate it. Look forward to the email. Thanks again.
Yep.
Have a good evening.
You too. Hey, Ned, anybody else?
Not currently. It's about 5:15, or quarter till
All right, we're
6.
gonna do a last call. Hey, Phil, did I miss anything? You got anything to add?
No, sir. No, sir. You covered it well. We've had some nice questions here. I appreciate the way you elaborate on those. Nothing to add from my end. I'll just take us out of here whenever we're ready. I don't want to jump the gun. See if we get
All right,
anything.
anything else, Ned? Going?
I
3,
think
2,
that's
1.
it. 3, 2,
All
1.
right. Okay, everybody, next week at this same time, same place. Look forward to talking to you. If you could, it would help us if you forward our link to your friends, family, acquaintances, colleagues, and let them know that I'm here to be able to talk to them about this. And hopefully you sense it's sort of low key as I can be, and just trying to give some information that might be helpful to them. And so hopefully we can help them. All right, everybody. Thank you.